Hi, welcome back. We're happy to have you here as a part of our weekly webinar. And this week, we're going to talk about how to speak like a NetLaw pro. This is a seminar based on understanding the vocabulary of law. And most of us on this, I assume, are not lawyers. We have not attended law school. In fact, the only time we need a lawyer was when we wanted to get out of a parking ticket or something, right? Or closing a real estate deal. Yeah, most of us, Jamie Hargrove has written a great book called The End of Lawyers. And most of us just tell jokes about lawyers, like, I saw something strange the other day, a lawyer with his hands in his own pockets, or what do you have when you have 10 lawyers buried up to their neck in sand? Not enough sand. So we all have jokes about lawyers, but talking like a lawyer today, we mean not describing any medical problem or a legal problem. We're talking about just using the language that you really want to understand when you're talking about net law. You don't have to be an attorney, but you really do want to understand what the terms are. Defining the terms is really important. When I was in college, I debated for the University of Kentucky as a debater through school that was able to pay my tuition and for my books, thank goodness, to the University of Kentucky. But we had to, in debate, the first thing you have to do is define your terms, because he who defines the terms really sets the stage for the debate. So I want to be sure you understand the terms, not because you want to debate, but you want to sound professional when you use language that some of your clients may be familiar with. Now, remember, most of your clients are not going to be really familiar with this language anyway. Some of your clients may have English as a second language or even a third language. And so these terms may not be any they've come across in their vocabulary, and sometimes they're really unfamiliar to us as well. So that's what we're going to talk about today, because when you discuss NetLaw with your clients, when you play the NetLaw video that's on step 6, there may be some terms in there that you will hear that you will need to explain to your client. If your client says, what is an executor, you need to explain that. If the client says, what's the difference between a trustee and an executor, you need to explain that. So that's what I want to do today. I want to help you learn this language, and I'm calling it the language of confidence. Why is that? Because once you get this language down, it will increase your confidence in discussing legal matters with your clients. Now, remember, you are not giving legal advice. That's why if this is your first day as an advisor, your first day as a consultant, you can begin to talk about NetLaw today, because you're not giving legal advice and you're not required to be licensed to talk about it. But you do want to sound like you know what you're talking about, right? So let's talk about them then. How to speak like a NetLaw pro, the language of confidence. Simon Cowell, you remember from when American Idol started, he was the endearing Englishman who sat on the end of the line and who made fun of everybody. Well, one of the things he said, which made sense to me, is sometimes singers would start and they'd forget the words in the song. They'd start repeating them, or they do la la la's. And Simon said, listen, you got to know the words if you're going to sing the song. That's pretty basic, isn't it? Can you imagine not knowing the words when you sing the song? That's true about NetLaw, just as it is true about singing a song. When you are speaking in public, you want to be sure that you understand the vocabulary, and not only understand them, but you know the words. So that's what we're going to do today. The song you're going to sing is why everyone that you speak to needs NetLaw, and the truth is they do. They do. If they're going to the hospital tomorrow, they need to have a durable power of attorney for health care. They need to have a living will, and they need to have the HIPAA authorities. If nothing else, they need that, and they need that today. They may be required to go to tomorrow to the hospital, so today they need to get that done. You got to know the words if you're going to sing the song. And what we do at NetLaw, is we divide it up into 3 bite-sized pieces. The first are the hospitalization documents. The second is the estate documents. The third, the legacy documents. So when you take estate planning and that big, huge ball of wax, and you divide it up into 3 simple things, it makes it so much easier. But there's words that describe each section. So that's where we're going to go today. Here's the words you need to know if you're going to sing the song entitled NetLaw. it's certainly my top 10. So know the words if you're going to sing the song. Why? Why do I have to know the words? Come on, I could just say, hey, this is the right thing for you to do. The question is, people are going to ask you questions. And if you know what to expect, it just gives you so much more confidence. Confidence comes in your presentation when you're not afraid or concerned that your prospect or your client is going to ask you a question about something and you're going to appear ignorant. None of us want to appear ignorant, especially when it's a product or a service that we are presenting to clients. We want them to have confidence in the presentation. We want to have confidence in the presentation because when we do, it creates confidence in our client because confidence is transferable. You know how that works. If you're very confident in what you're saying, if you're confident in your presentation, if your vocabulary sounds confident instead of hesitant, that conversational confidence transfers into confidence in the client. Confidence not necessarily in what you're talking about, but confidence in you that you know what you're talking about. So once you create that confidence in your presentation, it's transferable. Your client picks it up. And the reason is words matter. Words matter. If you have English as a second language, then you know how important it is that we understand or are able to communicate with words. And words truly do matter. That's why we study, and that's why we understand language, because we want to be sure that we say the right thing. There's a difference in the RITE thing, isn't there? The right thing and the WRITE thing. How you use those in a sentence defines them. And that's really important. Words matter. So I want you to get the words down when it comes to NetLaw. The terms may be unfamiliar to you. You may not have used the term executor in estate in a discussion at all. You may have, executor sounds like Skeletor, which sounds like a villain in a children's game or in a comic book that's done by Marvel, now owned by Disney, which is making huge headway in the world. The terms are unfamiliar, but they're not difficult. The other thing about these terms is that they're going to help you with your knowledge. But remember, knowledge is not power. The wise use of knowledge is power. So today, you may know these words. You may say, Stan, I've used these words before. I know what they are. But how to use them is what's really going to be important. So today, we're not just going to look at the terms. We're not just going to look at their meaning, but we're going to talk about how to use these terms, how to understand and share your understanding of them with confidence, because the use of them is what is powerful. And powerful in what? In offering this wonderful service to your client. Client expectations are either going to be met or their clients are going to be disappointed. Which one do you want them to have? Well, obviously, we want our clients' expectations to be met. So when we talk about NetLaw or talk about annuity or talk about a life insurance product or talk about an IRA, we want to be sure that we use the correct vocabulary, that we're able to explain them, and that we use those not to intimidate clients because we're smarter than you are, right? No. We want to use them to say, I want you to understand, and then have my presentation meet your expectations. Instead of getting through and the client said, I have no idea what you were talking about. Blah, 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 blah. I mean, goodness gracious. Have you ever been talking to someone and you just wonder, what the dickens are they talking about? They obviously didn't know that words matter. So let's start. Remember I said we want to divide them up into the NetLaw estate package into a presentation that makes it simple right from the start. So the right start, as far as I'm concerned, is the medical documents. Why? Because everyone you speak to needs to have these medical documents. Everybody you speak to, age 18 and over, college students, military person, by the way, military people do, it is required. It is required in the U.S. government for all of our personnel to have these documents in place because you never know when you're going to need them. But if it's correct for our soldiers, for our warriors, if it's correct for our missionaries, it's correct for our travelers, it's important for you. So what are the medical documents? Well, one is called a durable power of attorney for healthcare. a durable power of attorney for healthcare. What does that mean? Well, a power of attorney, you may say, well, I know what that is. We have powers of attorney. The truth is, as I've said before, a power of attorney is useless when you need it the most. And when do you need it the most? When you are unconscious and no one knows what to do. You're breathing, you've had a fall, you've had an accident, you've had a medical reaction, you're under anesthesia. Who can speak for you? A durable power of attorney means that your authority will endure even when the patient, or you, that is unconscious. It endures when a regular power of attorney fails. So this document is critical. A durable power of attorney for healthcare, that's the first thing you need, very first thing you need. And this document gives your spokesperson, also called the agent in some legal documents, the proxy in other documents, it gives that spokesperson, speaking for you now only when you cannot speak for yourself, the power to make your health decisions when you can no longer do that. What decisions can they make? Well, they can either accept or reject medical treatment, accept or retreat medical procedures. They can accept or get rid of a doctor that's on the team. They can move you from one medical facility to another if they think you're not being cared for. They have every right to speak on your behalf as if you were doing it yourself. And that's an important document. The medical document, the durable power of attorney for healthcare. And then the second medical document is the living will. There's some confusion about this because people get this confused with a will, with a blank will, with a last will and testament. A living will is an important document. It states the kind of medical treatment that you want, that you wish, whenever you're in a medical facility or under a doctor's care. Now, the reason you need this is because when you can't tell the doctor what you want, when you can't say to the doctor this is what you want, you can explain to the nurse what kind of treatment you want. A living will is your written direction about the treatment you want when you cannot express it yourself. It's where you specify what you expect in your medical treatment, as well as you do not want as part of your medical treatment. You have to write that down. And the reason you have to write it down, because it's going to govern your healthcare and your healthcare options when you can't talk. Well, we can always talk. In fact, some of us, talk too much, too often. We talk too much and say too little. Have you ever had that happen? Yeah, that happens occasionally. But if you're in a medical facility and you're under the effects of anesthesia, if you've passed out, you've fainted, you're unconscious, if you were in an accident, if you had a stroke and you can't speak, what kind of treatment do you want? A living will says, this is the treatment I want. This is the treatment I expect, and this is what I do not want as a result of an injury or illness that has rendered me incompetent. So a durable power of attorney says who's going to speak for you. A living will says what you want them to say. HIPAA Authority, Health Information Patient Protection Act. HIPAA, Health Information Patient Protective Act. Patient Protection Act. Once upon a time, if I was in the hospital, my aunt, my brother, my uncle, my nosy next door neighbor, the bill collector who's trying to get the payment out of me for my car, the guy who's trying to get the money from me from my utilities, they could call the hospital and say, hey, you got Stan Craig in there? Yeah. Well, how's he doing? Here, I'll transfer you to the nurse. How's Mr. Craig? Oh, he's really well. He'll be back at work tomorrow. Well, that may not be the message I want to, suppose it's my boss calling and I want another day off. The truth is a HIPAA authority means that no one can know your medical condition, your treatment, or anything else about your health from that hospital without your authority. That's what the Health Information Patient Protection Act does. It simply says, I give my health information as the patient to this person. And so in your NetLaw documents, you could appoint up to 5 people to hear your medical information directly from the hospital, the doctor, or the nurse. Otherwise, they can't speak to you. You may be your religious advisor, You may be your next door neighbor. You may even be a nephew or niece, but you cannot get that information unless the HIPAA Authority gives it to you. It gives your permission, and the medical facility your permission to describe your condition. They can do it either in person or on the phone to others, but not to everybody, to only those people that you assign. Without this document, listen, if your child's 18 years old and they're injured in a car wreck, or they fall out of the dormitory while they're at college, or they drink or swallow something that's rendered them unconscious, you can't get information if they're over 18 unless the student has given HIPAA authorities and a durable power of attorney for health care for you to get that information. It's really important. So we're going to include 5 of those authorities authorizing access and stored in your vault as a part of the medical package of your estate plan. So one of the important questions is, does this stuff has to be seen and notarized and signed? Well, the real answer to that question, unfortunately, is not easy. I wish it were, because I would tell you. These documents in some cases have to be notarized. The living will sometimes requires 2 witnesses, but it depends on the state where you live, which is really interesting, isn't it? Some states will say, I want every document to be notarized. You know, that means 2 witnesses, and it requires an ID, an affirmation, this is what I want, as well as a signature that's authenticated. That's what a notary does. I sent a document the other day to the state of Kentucky. I had to have it notarized, signatures done, and most places that can be done at no charge. I went to a real estate office. The notary came out and did that for me and helped me with the witnesses and with the signature. However, some states say, listen, we don't have any requirements. You don't need a notary. Just put your signature on there. You know, be sure it's your signature, not a typed signature, but your handwritten signature, generally in blue ink. Why blue? Because when you make a copy, everything is black and the same color. You want to see blue ink that shows that it is an original document. So most places would want the original, at least have access to it. So what you need to do is know what your state wants. That's the hard part, because that makes a huge, huge difference in what you're seeing. So now I'm unmuted. Sometimes I wave my hands around and I hit keys that I'm not supposed to hit. So there are also states which require notary for only a living will. The reason why they would require that for a living will is, in a living will, one of the provisions of a living will is a do not resuscitate. People get confused about that. They think do not resuscitate means, oh my gosh, just don't do anything for me if I'm dying. That's not what it means at all. Another way to think about do not resuscitate is, and this is what my wife and I clearly express, is it means when I'm dead, please let me go. When I'm dead, please let me go. That I really want a natural death. I don't want my heart restarted. I don't want a artificial breathing through a lung machine, oxygen machine to keep me. I don't want artificial nutrition to be feeding me sugar water. I don't want my chest bone split or ribs broken trying to get my heart to go again. I want a natural death. But because you're stating that, many times that has to be notarized and signed by witnesses as well. So whether you're in California or Connecticut, whether you're in Alaska or Arkansas, Kentucky or Kansas, you need to understand what your state laws are, and that's not difficult. Someone there in your firm, one of your mentors or partners, that means. So that's really going to be important for you to do. The next thing I want to share with you is this. Knowing your state laws ought to be your own responsibility, shouldn't it? But when in doubt, have all your documents notarized. Just make it simple. Having them notarized, you're going to need some of that done for the estate documents anyway. take them all to a notary and have that done, or have your client take them to a notary. Some of you may have a notary in your office where they could be done then and make it even easier for your clients. But know what your state law is about witnesses and notaries when these documents come up. Next thing I want to share with you is the financial side. We talked about that medical, which consists of 3 documents. What are they? Durable power of attorney for health care, and your living will, and your HIPAA authority. Now, the financial documents, the last will and testament. This document is where you determine the distribution of your assets under the law, which means because this is a legal document, the document states how you want your assets distributed. This document will only take effect after your death or my death. It's, well, mine, of course, after my death, yours, of course, after your death. My dying will not have anything to do with your distribution of assets. But it's important that you understand that a will is that document which tells others, particularly your heirs as well as the state, where your assets are going to go. It may mean the sale of your house. Where does the equity in that go? It may mean your car, it may mean grandma's necklace or granddad's shotgun or the pickup truck. But that's going to be important. And the truth is, you already have a will written, even if you don't know it. It's because, yes, the state has one already written for you. You already have a will. The state has written one for you, meaning that if you die intestate, which means you die without a will, then the state's will is the one that you'll be using. And it describes that 50% in some states, some states will go to your spouse, 50% will be divided among your children. That is after the state has collected its laws, local laws have collected whatever they want from your estate. It's part of the reason why we have a living will, rather not a living will, but a revocable living trust for you to place your assets in. So everyone's got to have a will if you don't want the state to write it. And if you have any dependents, you have to have a will. It doesn't need to be complicated, and NetLaw will make it simple for you. This description of assets is really important because it also says who are your specific beneficiaries. Are your children, all your children, going to be treated? What if one of your children is a person who lives a kind of lifestyle that you think is destructive? In fact, nearly everybody you know would think this kid's really destructive. Even her friends or his friends think this keeps up, she's going to be in real deep trouble. Well, you may not want to leave as much to that child, or you may want to leave that in a trust. So that's what a will does. It allows you to say that. Or you may say, listen, I want to give it to my children over a period of 10 years. I don't want to all be given at once. That's why a will can really be important when you describe your assets and how you want them received. Here's the problem, though. It's got to be created by a competent individual. What does that mean? That means, number one, that you are awake and intelligent. Awake, you're not only awake, but you are aware. Aware means, who the president is, what year it is, what your name is, all those simple tests to be sure that you know what you're talking about. The reason I mention that is because there are some patients in the hospitals or nursing homes or the victim of falls or strokes who may not be under the law capable of writing a will. Then that means the state has taken care of that for you. That's why you don't want to wait to get this stuff done. You really want to do it now, as soon as you can, and get your last will and testament taken care of. Not only is that important, but you're going to find that handling the finances on your behalf is really critical as well. Remember, we talked about a durable attorney for finance as much longer ago in our seminars, like we talked about a durable attorney for healthcare. And durable means what? That it will endure even when you do not. Finances is really important. I mean, it's critical. Your agent, your proxy, the other terms that are used. This person must be carefully and thoughtfully chosen because they're going to speak by you even while you're living. A durable power of attorney can go into effect whenever you want it to. You don't have to wait until you may be unconscious or incompetent. And what you need to do when you do this is have a second person, an alternative. You don't want a co-durable power of attorney because two people getting to agree is very difficult, but you want to have somebody who's checking up on who's making those decisions. So an alternative is really responsible. A durable power of attorney for finance is a powerful document. They can write checks, buy and sell houses under your name, buy and sell real estate. Anything that you can do, they can do. They can determine who is going to be the beneficiaries of your will. There's a lot of stuff a durable power of attorney for finance allows a person to do. Bad people have drained checkbooks. And as I say in my book, Foretalk, Donald Sutherland in the movie The Italian Job said, listen, I trust everybody. I trust everybody. It's a devil in them I don't trust. And sometimes money can cause serious problems. I mean, the devil can enter in the form of greed. So you want to be sure that you have someone you can count on to do that. The other thing that's a part of a will is legacy giving. Let me tell you why that's important. Jamie Hargrove, our founder, in his book talks about, and in his documents, a child named Charity. And that is, when we leave our assets, we may want to include a child named Charity. There are organizations, religious and fraternal, educational, community, social, that depend upon the gifts of others in order to be able to carry out their mission. In your will, you can designate a beneficiary who's not a member of your family. Remember, the state won't do that. That's important to you, that you want to share your assets to support that group in whom you believe. Local and federal government's going to guarantee take a portion out. You know, your children is going to be remembered most often equally. It depends on how you want this done, but certainly in the state. And then the organization you belong to and institutions you serve, they're not going to be remembered. 2 out of 3, that's not really good if you're a caring person. So you may want to be sure that you include a legacy gift, a portion of your assets, a portion of your estate to be given to this organization or institution when you pass away. You need to write it down or it won't get done. This is included in your last will and testament if you choose. Because if you can just say, well, granddad liked, or mom really believed in, or the local quilters organization, or the local Red Cross, or the local Red Crescent, or whatever it is, these are things that are important to our family. And that's the reason dad or grandmother or mom or dad want to remember them. But it won't get done unless you write it down, because someone's going to say, oh, I don't think that's true. No, I think it all should come to me instead. Legacy giving is important, so write it down. Now, here's the terms you need to know. Remember, we talked about your vocabulary. This is going to be pretty quick, but I want you to get these down because I think they're really critically important. The executor. This is the person named in your will to carry out your wishes. Notice, this is the person named in your will. An executor is named in your will. When you do that, be sure to name a second and sometimes a third. Don't ever have co-executors. I've had people say, well, Stan, I want my son and daughter both to be executors. Listen, it just doesn't work. There can be decisions that are misinterpreted and misunderstood. So be sure you only have one executor. You can have an executor who's an alternative executor and a third or fourth alternative executor, but only one person at a time. A bequest, that's a gift made through your will or your estate plan. I made a bequest to my church. I made a bequest to an educational institution. I made a bequest to the University of Kentucky. I made a bequest to, that's anyone for whom you are making a gift. Who is that person? The person is the beneficiary. So the executor fulfills your bequest to give a gift to this person as your beneficiary. See how that works? They're all related. An attorney in fact, that's another term for your designated agent in your powers of attorney. Don't use that term because it's a long term. It's not always used. The term agent is used or proxy is used. The durable power of attorney is sometimes just called the durable power of attorney. But when you see attorney in fact, that means the designated agent for those two powers that we talked about, the durable ones. The alternate, an alternate is the person you've chosen if your first choice is not available. Doesn't mean you have an alternate will. Certainly you don't want two wills. You don't want an alternate living will. You just want one, but you want an alternate person, first, second, and sometimes third alternate if the person you've chosen can't do it. Now, you know your NetLaw documents include a revocable living trust. This is a trust created in the lifetime of the trust author. It will hold retitled estate assets in the name of the trust and names a trustee that replaces a probate judge. So let's just, when you buy a car, you buy it in your name, right? Or your child's name or a name. When you buy a home, you put it in somebody's name. But what happens when you're no longer alive? Well, those assets have to be retitled. And that's when probate takes place, because the state is telling everyone we're going to have to retitle these assets. Maybe there's somebody out there who is entitled to a portion of these assets. And that's what happened to my brother. As you know, he did not have this trust done. He did not take advantage of the benefits of NetLaw. And unfortunately, his assets went into probate. We had people come to claim his assets, and it took 2 years to settle his will. His will was challenged by two people who we didn't even know. A revocable living trust avoids that. The trustee, I mentioned to you earlier, that's the person named to manage the assets in the trust. An executor directs the terms of the will that they are fulfilled. A trustee follows out your request according to the trust. An executor acts only when you are deceased. A trustee may be named now and are managing the assets when they go into the trust, usually too after you are deceased. So you don't need to know everything about this. You know, sometimes, wow, Stan, we're covering a lot of stuff today. That's true. You don't need to know everything. When I was studying a difficult subject in my seminary, my professor said, you don't need to know everything, but you need to know how to find the answers to everything. And that's why you don't need to be discouraged as a financial advisor thinking you have to know everything. The truth is, you don't have to know everything. All you have to know is where to find the answers. So don't think, well, I've got to be a legal expert. Just think, I need to understand the terms. Once you do that, you can talk about NetLaw. Even though the terms may be unfamiliar, they're really not difficult. That's what we've tried to help you understand today. Now, I want to give you two great things that you can do when you want to know more about this. One, call the support team. You know that Mark and Jennifer and Vanessa and Mary are ready there to help you. You know you can check on the NetLaw website, but here's the best thing. Here's a secret. You can email a request for a complete vocabulary to Vanessa at vherod@netlawinc.com. Write that down and just say, Vanessa, send me the list of support terms. Send me the vocabulary. And Vanessa will get that out to you within the next day or so. Frankly, Vanessa showed me the vocabulary, and I was impressed with all the work that she and Mark and the team had done together. So we want to send that to you. Just drop a note, an email, send me the vocabulary to Vanessa Herod at netlawinc.com. Now remember, our support team's not just there for you, but the good news is we'll talk to your clients as well. You don't need to know everything, but you need to know how to find the answers. You can do that by calling the support team, checking the website. Be sure to email Vanessa. And remember, we're there to help your client too. I think once you get this down, once you understand you're not alone, it's going to build your confidence as well. And remember, when your confidence is strong, you pass that confidence right on to whom? To your client, and they have their confidence in you. I hope this vocabulary has been helpful to you today. I know Vanessa's document, the one that she and Mark and Mary have put together, will be really beneficial to you. Next week, we're going to talk about something else. I'm going to talk about how to be an expert in whatever you want to do. I'm going to show you the 8 things you need to do to be an expert financial advisor to create wonderful confidence in you that you can pass on to your client. That's our message next week, how to be an expert in your financial advisory service. I think it'll be really important to you, and we're going to talk about how NetLaw helps you do that. So join us again next Law. Thank you for coming today. Be sure and check out Step 6. I'm telling you that you can use the video on Step 6 to bring clients into your office to purchase the NetLaw service just by watching that video. Check out Step 6 in the App Store. Remember, there's our number, 1-888-604-4789. And then also remember another thing, too. We really care about you and your business. We're here for you. From 8 until 8, one of our folks is glad to talk with you or talk to your clients. NetLaw, we want to help you be more and more successful because, frankly, your success makes us more successful. Well, I'm Stan Craig, and if I can help you in any way, you can always email me, drop me a note. I'm happy to chat with you. And frankly, if these webinars are helpful to you, drop a note to me again and let me know if you have any ideas about what I can do to be more helpful to you or to your team. And by the way, if you're new to NetLaw, remember, for the first 30 days, as Mark said, you get buy one, get one free. Sounds like a deal to me. Thank you so much for joining us. This is Stan Craig. I'm looking forward to next week when we talk about becoming a NetLaw, a financial advisor expert. Thanks much.